Hello. For those of you who don't know me, my name's Anthony Tanney and I'm a barrister at Falcon Chambers, and I'm going to be speaking to you today on the topic of leases and the doctrine of frustration. This lecture is in broadly three parts. In the first part I look at the doctrine of frustration generally. In the second I look at frustration and its application to leases in general. And then in the third part I examine two case studies, the Brexit case and the current pandemic. We need to start with a working definition of frustration. The doctrine of frustration operates to discharge an executory or partly executory contract where an event occurs after the contract is made, a so-called supervening event, which has one or other of three consequences. These are: 1. That performance of the contract becomes impossible; 2. That performance becomes illegal; 3. That performance remains possible and legal, but the supervening event makes the subject matter of the contract radically different from the parties' expectations when the contract was made. No definition of frustration is complete. This one is no different. But we have to start somewhere. Taylor and Caldwell is a case of the first type and marks the birth of the doctrine in English law. Mr. Caldwell owned a concert venue in Surrey, which he agreed to make available to Mr. Taylor, a music promoter, for concerts on 4 separate nights. Mr. Taylor incurred expense promoting the concerts. But before the first one, the venue burnt down. Mr. Taylor sued Mr. Caldwell, alleging he'd breached his contract to make the venue available on the 4 nights in question, and seeking damages to compensate him for his wasted expenditure. The court rejected the claim on the basis that the fire made performance of the contract impossible, and the contract was accordingly discharged. Impossibility of this type can take an almost infinite variety of forms. There is no conceptual limit to impossibility. Almost none, at any rate. With Professor Tritle, we may note that in contemplation of law, the payment of money, including rent, is never impossible. Wartime restrictions on trading with the enemy provide plenty of examples of cases within our second type, that is to say, cases where performance of a contract has become illegal. Thus, in the Fibrosa case, performance of a contract made in July 1939 to sell machinery to a buyer in Poland became illegal when, at the outbreak of war, Poland was occupied by German forces. As a result, the contract was frustrated. Illegality for the purpose of this second type of frustration generally means something equivalent to a criminal or regulatory offence, as opposed to a civil wrong. In the case of a statutory body, it can also mean something which is ultra vires that body. We come back to this when we look at the Brexit case later. The third type of frustration case is where the supervening event makes the subject matter of the contract radically different from the parties' expectations when it was made. Krell and Henry is a well-known case of the third type. Mr. Krell agreed to let rooms to Mr. Henry. The letting was arranged for the day of King Edward VII's coronation procession, and the rooms overlooked the route. But the king became ill, and the event was postponed. Mr. Henry had paid Mr. Krell part of the hire fee up front, but he refused to pay the balance, and Mr. Krell sued for payment. Mr. Henry successfully defended the claim on the basis that the postponement of the procession radically altered the real meaning of the letting of the rooms. It's important to note that the postponement of the procession did not put Mr. Krell in breach of contract. His obligation was to let rooms. He was still able to do that despite the procession being postponed. He gave no warranty in the contract that the procession would go ahead, nor did he agree to act as underwriter of the king's health. Therefore, Mr. Henry's expectations in that regard were what we might call non-promised expectations. But the court was willing to look beyond the 4 corners of the contract and take account of those non-promised expectations. In Krell and Henry, the court was willing to look at extrinsic evidence to see what the paying party's non-promised expectations were. But those expectations may appear from the contract itself. The important point is not whether the expectations are disclosed by the contract, but whether or not the supplier under the contract, the party in Mr. Krell's position, underwrote the paying party's expectations with a contractual promise of some kind. If he did, the buyer will have a claim under the contract if his expectations are confounded by events. If not, the buyer will have to argue that the contract is discharged by frustration. An example of what I mean may be found close to home. Most leases contain user clauses, permitting use of the premises for some more or less specific purpose. The landlord gives no implied covenant or warranty that the premises are fit for that use. So if a supervening event interferes drastically with that use, the tenant has no redress under the contract itself, but the user clause may yet provide evidence of the tenant's non-promised expectations in a Krell and Henry sense. I want to dwell for a further moment on cases where the supervening event takes the form of a change in the law. Clearly, such changes may be relevant to a defence of frustration in the second of our three categories, that is, where performance of the contract becomes illegal. But such changes can also be relevant to the third category, involving a radical departure from non-promised expectations. This is shown by Cricklewood and Leighton from 1945. This case concerned a building lease of the site of an intended shopping centre. The tenant agreed in the lease to pay a substantial rent for the site, on the basis that it could quickly proceed to build and then sublet the shops at a substantial profit. But when war was declared, laws were introduced to conserve resources for the war effort. While they lasted, those laws made it illegal for the tenant to construct the shopping centre, and the site remained a bare site. The tenant refused to pay rent, and the landlord sued. The tenant had no means to avoid payment under the terms of the lease themselves. The landlord had given no warranty that the shopping centre could lawfully be built. The tenant's only course was therefore to claim that the change in the law had defeated his non-promised expectations as to the exploitability of the site and had caused the lease to be frustrated. The law lords split 2-2 with one agnostic on the question of principle as to whether the doctrine of frustration could ever apply to a lease. We now know that it can, as we shall see. But the tenant's argument failed 5-0 on the facts. The legal change was expected to be temporary, whilst the lease itself was for a term of 99 years. So the change had wrought no radical difference in the bargain. But had the change been permanent, or the lease shorter, the new laws could have frustrated the contract on a Krell and Henry basis. Where the doctrine of frustration applies, it effects a transfer of the losses caused by the supervening event. But for frustration, Mr. Caldwell would have had to pay Mr. Taylor damages for his wasted promotional costs. Because of frustration, Mr. Taylor had to bear those losses himself. But for frustration, Mr. Henry would have had to pay the balance of the hire fee to Mr. Krell. Because of frustration, Mr. Krell lost his right to payment of the balance. It is, however, noteworthy that Mr. Henry had counterclaimed against Mr. Krell for the return of the portion of the hire fee that he'd paid up front. But he abandoned that claim at trial because in the meantime the Court of Appeal in another coronation case had ruled such a loss lay where it fell. The reason for the Court of Appeal decision was that frustration discharged a contract prospectively only, as from the date of the frustrating event, and did not cause the contract to be rescinded ab initio. Two later developments in the law mitigated this position. These were the Fibrosa case and the Law Reform Frustrated Contracts Act 1943. The way each of these developments works is explained in my written paper. Both developments allow some degree of restoration of benefits passing under the contract prior to frustration. As such, both take effect as part of the law of restitution. Neither development affects the rule of the law of contract that discharge by frustration is prospective only. We should note one point arising under the 1943 Act concerning leases. Where a lease is frustrated midway through a quarter and rent is payable in advance, the effect of the 1943 Act is to entitle the tenant to repayment of that portion of his advance rental relating to the period after the frustrating event, on the basis of a partial failure of consideration. Frustration applies only where both parties are innocent in relation to the supervening event. That being the case, the law might have taken the view that the loss from that event lies where it falls, and is not to be transferred in whole or in part. In a case where the event makes performance illegal, the law's intervention can be justified on the basis of a public policy to relieve people from contractual liability incurred in obeying the law. But in the cases involving other types of frustration, why should the loss be transferred? The law acknowledges this question in frequent statements that the doctrine of frustration should not be too widely applied, and that the doctrine is not a general jurisdiction to adjust loss. But that does not tell us why some cases are deemed suitable to adjust loss, and some are not. In cases of impossibility, for hundreds of years the law took the view that the loss should not be transferred and should lie where it fell. This was the so-called rule of absolute contracts, most famously stated in a Civil War case called Paradine and Jane. But in Taylor and Caldwell, the court, while purporting to respect the rule, hollowed it out by stating parties could not be supposed to expect the absolute rule to apply under a contract that had become impossible to fulfill. As a justification for transferring the loss, this seems somewhat thin to me, but the law has proceeded on more or less that footing ever since. In our third type of frustration case, typified by Krell and Henry, the law again acknowledges that the sharing of loss requires justification, especially since, as in Krell itself, the letter of the contract remains performable. The law finds such justification by seeking to implicate the contractual supplier in the non-promised expectations of the paying party. Thus may be found in the books and the cases statements that a contract will be discharged where the party's common purpose for making the contract can no longer be achieved. I mention common purpose because it rears its head in the Brexit case, which I'll come to. But I cannot move on from it without noting that there are few areas of law whose central organising principle is as easy to debunk as the notion of common purpose in the law of frustration. I entertain myself doing just that in the written paper. Perhaps I may entertain some of you too, if you elect to read it. Frustration is a very blunt way of dealing with losses arising from a supervening event. Although the contract is discharged only for the future, nevertheless, as respects the future, it is the whole contract that is discharged, not merely those obligations affected by the supervening event. And the contract is discharged not only completely, but also permanently, without prospect of revival. For these reasons, a supervening event will not discharge a contract unless its effects go to the very foundation or root of the contract, and those effects are sufficiently long-lasting when measured against the duration of the contract itself. One unresolved point involving contracts lasting a period of time is whether the comparison is between the duration of the supervening event and the total contract length, or whether it is between that duration and the length of the unexpired residue. Some cases suggest one answer, some another. In some cases, notably the Panalpina case, there are differences between the judges themselves. If frustration is a blunt instrument, a cosh if you like, the same cannot be said of another rule of law, applying not to contracts as a whole, but to specific obligations whose performance has become illegal. The rule in question protects the performance debtor from liability on the specific covenant, while leaving the remainder of the contract intact, including, in a lease, the obligation to pay rent. This rule is thus a scalpel rather than a cosh. The scalpel was the subject of prominent mention by Lords Russell and Goddard in the Cricklewood case. The point arose because the construction of the shopping centre was not only the means by which the tenant hoped to exploit the site, but was also something which the tenant was obliged to do under the lease as a matter of covenant. The scalpel, said Lords Russell and Goddard, would have protected the tenant from an action for damages for breach of that covenant, but offered no defence to the actual claim, which was for rent. No occasion to actually deploy the scalpel therefore arose in Cricklewood, but it was applied more recently in John Lewis Properties and Viscount Chelsea. That case concerned a 999-year building lease. After the lease was made, the building in question was listed, and the evidence before the court was that the necessary listed building consent for the works would not be obtained. The tenant went to court to seek declarations that it would not be liable on its covenant to undertake building works on the basis that to do so would be contrary to listed buildings legislation. Mr. Justice Mummery granted the declarations, stressing that the tenant's liability could revive if, over the course of 999 years, the legislative environment changed. This case therefore shows that, unlike the doctrine of frustration, the effects of the scalpel can be suspensive and therefore more easily tailored to the justice of the case. Three important points must be made about the scalpel. First, it does not apply in cases where it has become impossible, as opposed to illegal, to undertake the acts needed by way of performance. This point was decided in a case called Stirk and Edwards. The reason seems to be that the public policy in favour of discouraging parties from breaking the law in order to perform their contracts has no echo in cases of mere impossibility. Second, there is no doctrine of any kind that extinguishes or reduces, whether temporarily or permanently, or holds in abeyance, a contractual obligation to pay money in a case where a supervening event deprives the paying party of his non-promised expectations, but not so radically as to effect a frustration. Third, and this is to repeat, in the John Lewis case, the tenant was excused liability only on the covenant that could not lawfully be performed. The lease itself was not discharged, and all the other covenants of the lease therefore remained in force. The only means by which performance of one covenant can be excused, because performance of another becomes illegal, is by frustration. And if the illegal covenant does not go to the whole or substantially the whole of the contract, that will not be the case. The doctrine of frustration will not apply if the parties make clear by a clause of their contract where the loss from the supervening event is to fall. One example touched on already is a warranty. Another type of clause allocating loss is a force majeure clause. Whereas a warranty almost certainly will exclude frustration, a force majeure clause may or may not do so depending on its construction. Some leases include limited force majeure clauses in the form of rent cessor provisions, and I consider the effect of such clauses on frustration later in this talk. In addition to ouster by agreement between the parties, the doctrine of frustration can effectively be excluded by other legal rules. A well-known example in the property sphere is the rule that on exchange of contracts for the sale of land, physical risk passes to the purchaser. As a result, if the property is destroyed between exchange and completion, the purchaser cannot escape the contract on that ground and must still pay the purchase price, hopefully out of the insurance policy that he should have taken out on exchange. This rule applies on the sale of freehold or leasehold land. The position as to passing of physical risk on the grant of a lease is something to which I return later. Three final points on the general law of frustration concern 1. Foreseeability, 2. Compensation from other sources, for example the state, and 3. Mitigation of loss. I shall leave you to look at the written paper for points on compensation and mitigation, but I want to briefly mention foreseeability. Where a supervening event is foreseeable, the law could take the view that the parties ought to have provided for that event in their contract or insured against it. So if the event happens, and the parties have failed to make appropriate provision, the contract will not be discharged by frustration. But foreseeability has a more minor and uncertain role in the doctrine than one might expect. One reason is that foreseeability means different things to different people. As Prince of Wales, King Edward VII led something of a rock and roll lifestyle, arguably increasing his susceptibility to illness. Indeed, contemporaneous evidence suggests that even at the date Messrs. Krell and Henry made their contract, there was publicly expressed disquiet about the state of the King's health. But the court deciding the case certainly appeared to regard the risk as unforeseeable. The second problem is that the answer to the question whether a supervening event is foreseeable may depend on how you define the event. Take the COVID-19 pandemic. Is the supervening event of which a tenant might wish to complain the pandemic itself, or the government's response to it in the form of lockdown? A pandemic might be foreseeable, but does it follow that lockdown, or perhaps more accurately the precise form of lockdown, was foreseeable? Look, for example, at Sweden. And how you define the supervening event is a matter which itself conceals a further question, again illustrated by the pandemic. What is the cause of the frustrated party's loss? Was it lockdown? Or would customers have stayed at home anyway, not out of legal compulsion, but out of fear of catching Covid? Again, evidence from Sweden could be relevant. Some of these issues are touched on in the business interruption insurance case, FCA and Arch Insurance. Judgment in that case was handed down 2 days before the recording of this lecture, and it may of course feature again in the Q&A that follows the broadcast. It's time we moved from general considerations of frustration to focus on leases, and we segue effortlessly from one to the other via the Panalpina case, which, as well as being the case that decided that the doctrine of frustration is capable of applying to leases, is also a leading case on the doctrine of frustration in its own right. As noted earlier, I shall look first at general considerations affecting leases, before looking more closely at the Brexit case and the current pandemic. The facts of Panalpina concerned a lease of a warehouse for a term of 10 years from the 1st of January 1974. The lease reserved a market rent and contained all the usual covenants and other provisions you would expect to find in a commercial lease, including a rent cessor clause. In May 1979, the local highways authority, acting under legal powers, closed for an expected period of 20 months a road which was the only access to the warehouse. The tenant, appellant in the House of Lords, refused to pay rent, and the respondent landlord therefore sued for a money judgment. The tenant defended the claim based on an allegation of frustration of the Krell and Henry type. The issues in the House of Lords were 1. Did the doctrine of frustration apply in principle to leases? And 2. If it did, was this lease discharged by frustration in the events that had happened? On question 1, the question of principle, the House of Lords decided 4-1 that a lease could be frustrated. All of their lordships decided issue 2 in favour of the respondent landlord. On issue 2, the case produced some of the classic general descriptions of what must be shown in order to sustain a frustration argument, which you can look up quite easily in the textbooks. The main reason why the tenant's argument failed on the facts was that out of a 10-year term, it had lost less than 2 years of use. The majority of the House of Lords said that frustration of a lease, where it does apply, brings the leasehold estate, the term of years, to an end. Immediately, that makes frustration of leases different from frustration of other contracts. In the case of other contracts, as we've seen, frustration simply absolves the parties from future performance of their obligations. It does not undo what has been done under the contract in the past. But in the case of a lease, the doctrine also terminates the estate in land created by the lease, the term of years. It's important to note that this estate does not accrue from day to day, but is granted whole at the start of the lease. The estate also exists independently of the lease that created it, a point vividly illustrated by the rule that an assignment of a term of years is valid even if the lease prohibits or restricts such assignments. Thus, in the case of leases, the doctrine of frustration, in addition to discharging the parties from their obligations under the lease, takes an existing piece of property with a life of its own independent of the contract that created it, and causes it to cease to be. We can raise our eyebrows at that, but the law is what it now is. Frustration is added to the list of ways of terminating a lease. If we reconcile ourselves to that curiosity, there is no additional difficulty in applying the doctrine of frustration where the term and the reversion under a lease remain vested in the original parties. But that is not so in the case of parties who are landlord and tenant by assignment. Their relationship is not contractual, but arises as part of the law of property, under either Privity of Estate or the Covenants Act. In Panalpina, the parties were the original parties to the lease. The House of Lords did not discuss the position of assignees, and the position in such cases is not therefore covered by authority. I suggest that to apply frustration, which is part of the law of contract, to a case involving assignees would breach the line between property and contract, a line which, in another context, Lord Millett has said must hold if the law is to retain its fundamental coherence. Because frustration brings the leasehold to an end, the liability will also end of any surety for the tenant's obligations. Interests derived out of the term will end too. The principal such interests are subtenancies and charges. This sounds like the sort of thing that might cause problems, but for reasons explained in the written paper, those problems I suggest are more apparent than real. At a general level, there is no reason why the grounds for discharging a lease by frustration ought to be any different from those applicable to other contracts. But in their application, those principles may be affected by certain peculiar features commonly found with certain leases. Starting with length, take the case of a tenant who alleges that his non-promised expectations regarding the lease have been interrupted by a supervening event. The impact of the event would for this purpose have to be felt for a sufficient proportion of the remaining term of the lease, and the longer the lease, the less likely that will be. As Lord Simon pointed out in Panalpina, it will take something exceptional to frustrate a 1,000-year lease. Next, the fact that the lease creates an estate in land did not stop the House of Lords in Panalpina from ruling that frustration could apply to leases. But the fact may yet be relevant in another way. The issues arising are shown by the Schlesinger case. In that case, an Austrian national took a letting of rooms in Southend, but at the outbreak of World War I he was declared an enemy alien. Enemy aliens could not live in Southend because of its position on the Thames estuary. Mr. Schlesinger said, somewhat perhaps counterintuitively, that being unable to live in Southend was a deprivation of benefit, causing the tenancy to be discharged by frustration. His argument failed. Mr. Schlesinger could not use the premises himself because of a characteristic personal to him, his nationality. But, the court said, he still had the benefit of the tenancy, which could be assigned or sublet to someone who was not an enemy alien. The conferral of that benefit was part of the parties' common purpose when the tenancy was granted. This strikes me as a very harsh decision. Despite being described as a benefit by the court, Mr. Schlesinger's ability to assign or sublet was not of itself a positive benefit, but was simply an alternative means of dealing with the supervening event by offloading the rental liability elsewhere. There was, for example, no evidence that Mr. Schlesinger could sublet at a profit rental, and in the absence of any evidence it was at least as likely that he would do so at a loss, if he could do so at all. Viewed that way, the case was really about mitigation of loss rather than deprivation of benefit. But whatever the correct analysis is, the Schlesinger case stands as authority that where the supervening event specially affects the original party to the contract, but the contract itself is assignable to someone not so affected, as is the case with most leases, then the contract is unlikely to be frustrated. In its application to leases, the Krell and Henry principle is also likely to be affected by the scope of the user permitted under the lease. If the lease allows a relatively wide range of uses, the fact that a supervening event affects the particular use that the tenant happens to make of the premises at the time will be unlikely to work a frustration. The prospect for a frustration claim may be somewhat better if the permitted use is very narrow, and the event precludes that use entirely, particularly if at the date of the supervening event the term has very little time left to run or was short to start with. The question whether a lease has been frustrated may also be affected by certain terms commonly found in leases. I noted earlier the rule that on exchange of contracts for the sale of freehold or leasehold property, physical risk passes to the purchaser. But there is no rule that physical risk passes on the grant of a lease. The risk of supervening damage to the premises simply lies where the lease provides. That is to say, it lies where it falls, unless adjusted by the repairing covenant. The relevant general rule is that a party who covenants to repair must do so regardless of the cause of the disrepair, even if that cause is damage by a supervening event, unless such a cause is expressly excluded from the repairing covenant. However, this general rule is balanced by the fact that in a case of serious damage, such as one might expect from a supervening event, the work required to put the defect right may be too extensive to be properly called mere repair. In such a case, it may be no one's responsibility under the lease to do the work, and this fact may open the door to the possibility of a claim that the damage has frustrated the lease. Some leases incorporate a scheme to deal with the case of damage to the premises caused by a risk for which the landlord has insured. The scheme will exclude such damage from the tenant's repairing covenant and will include a special provision in its place. These special provisions are often called rent cessor clauses, but they include much more than that. Usually, the landlord covenants to insure the premises against damage caused by certain risks, and, in the event of such damage, to pursue a claim and lay out the monies on repair. If the damage makes the premises unoccupiable in the meantime, the tenant benefits from a rent cessor in that period. In practice, many rent cessor clauses will oust the doctrine of frustration in relation to physical damage. This is likely to be the case if the clause includes a term that if the damage cannot be repaired, one party or both may terminate the lease by notice. By definition, such damage will be at the most serious end of the scale, which would frustrate the lease in the absence of a rent cessor clause. But much will depend on the drafting of the particular clause in question. The presence of a rent cessor clause may have implications even in relation to a supervening event not consisting of physical damage to the premises and therefore falling outside the rent cessor clause. In particular, if the rent cessor clause applies to very serious damage, enough to otherwise frustrate the lease, does the presence of such a clause help show what the parties contemplated with regard to losses caused by other types of serious supervening event? I suggest a rent cessor clause ought in principle to be of no assistance at all on that question. The question posed by frustration is simply, should the contract be maintained or discharged? It is an all or nothing question. A rent cessor clause is a carve-up, a middle way that modifies the parties' obligations rather than simply adopting one or other of the two all or nothing solutions. But most importantly of all, a rent cessor clause applies to damage caused by insured risks. It affords no guidance at all as to the parties' intentions in relation to other types of supervening event, the risk of which may not be the subject of insurance. The significance of a rent cessor clause in frustration claims not involving physical damage was discussed in Panalpina. No majority view emerges, however, so the position as a matter of authority is in some doubt. We've now reached the point in the lecture when it's time to indulge everyone's proper fondness for nostalgia. We're going to talk about Brexit and about the European Medicines Agency case. The facts concerned a lease of part of an office building in Canary Wharf, granted to the EMA in October 2014 for a term of 25 years with no break. The lease contained the usual range of tenants' covenants, including a covenant not to use the premises except as offices, the usual Baroque alienation covenant, and a rent cessor if the property was damaged or destroyed so as to be unoccupiable. Following the Brexit referendum, the court was asked in declaratory proceedings to rule upon whether or not the lease would be frustrated in the event of a so-called no-deal Brexit on the original Brexit day in March 2019. The court was also asked to consider other exit scenarios, but they were all less drastic. So if the court found that a no-deal Brexit would not frustrate the lease, nor would the other permutations. The EMA argued that the lease would be frustrated on two bases. The first was that Brexit would make it ultra vires and illegal for the EMA to perform all of its covenants under the lease, including the covenant to pay rent. Second, the EMA said that Brexit removed the parties' common purpose in entering into the lease, which was an allegation of Krell and Henry type frustration. Both of these bases of frustration were based on the particular characteristics of the EMA as an emanation of the EU. To an ordinary office tenant under the same lease, Brexit would not have had anything like the same impact. The position of the EMA was thus like that of Mr. Schlesinger at the outbreak of World War I. If not quite an enemy alien, then at least an entity specially affected by the supervening event in question. On the face of it, therefore, the decision in Schlesinger was a major problem for the EMA on both of the bases of its claim. Unless that decision was distinguishable or wrong, it meant that the EMA's argument would fail on the ground of the assignability or sublettability of the lease to an entity not affected by Brexit in the way EMA was. The EMA sought to address this problem in two ways. First, it argued that although the lease was assignable and sublettable, nonetheless, as a matter of EU law, the EMA lacked the legal powers to enter into any such transactions. Second, the EMA said that even if it had legal power to assign or sublet, that was not the common purpose of the lease, which was instead that of personal occupation of the premises by the EMA. Having examined the relevant provisions of EU law, the judge rejected the argument that following a no-deal Brexit, the EMA would have no legal power to pay the rent or perform the covenants. That disposed of the first way the EMA put its case. But the judge said even if he was wrong about that, the EMA still had power to assign or sublet the lease. This further conclusion meant that the success or failure of the EMA's Krell and Henry argument turned on the contention that the parties' common purpose in making the lease was that of personal occupation by the EMA. If that contention was right, it meant that the parties' common purpose could be described in a more limited way than in the Schlesinger case, and that the assignability or sublettability of the lease, which was decisive in the latter case, did not defeat the EMA's argument. The judge therefore examined extrinsic evidence of the parties' negotiations. He was entitled to do this following the Krell case itself. He found that the EMA had sought, but the landlord had refused, the inclusion in the lease of a tenant's break clause. He also noted the complex, albeit to us landlord and tenant lawyers rather commonplace, alienation provisions in the lease. From this material, the judge concluded that the parties did contemplate that the EMA might at some point cease to have personal use for the premises, and that if that happened, the lease would continue and would not be broken, and that the EMA would seek to dispose of the lease in some other way. Therefore, the EMA's second way to put its case also failed. And so, finally, to the pandemic. Shakespeare wrote that when sorrows come, they come not single spies, but in battalions. The COVID pandemic is a vivid illustration of this. The pandemic has resulted in hundreds of thousands of deaths around the world, and an unknown number indirectly. It has ruined livelihoods, interrupted family relationships, often very seriously, and made life even harder for those already struggling in all sorts of challenging situations. As we ruminate on the jurisprudential aspects of the pandemic, we do so with its victims uppermost in our minds. A pandemic is capable of being a frustrating event. So too, therefore, is lockdown prompted by a pandemic. You all know very well what evolving form lockdown took and is taking. If you need a reminder, you can find one in the written paper. In parallel with lockdown, the government gave financial and other support to businesses and their employees, such as the furlough scheme, deferral of tax deadlines, and so on. Again, those hungry for detail will find it in the written note. In addition, legal restrictions were introduced upon certain landlords' remedies for recovering rent arrears. As everyone knows, these restrictions, themselves of finite duration, albeit recently extended, have not affected the tenant's underlying liability to pay. The problem of rent payment has therefore only really been put off until a future time. The crunch is yet to come. The legal restrictions on certain remedies for unpaid rent presuppose that at least some leases, doubtless the vast majority, will not be frustrated by lockdown, but will continue notwithstanding. But that does not necessarily mean that all leases will do so. Nonetheless, it will be a very rare thing indeed for a lease to have been frustrated by lockdown. Of course, the point has been made lots of times in lots of places that many tenants will not in fact want to claim that their lease has been frustrated by lockdown. Frustration would end the lease permanently for all purposes, whereas most tenants will wish to retain the residue of the term, or their statutory rights to renew the term, for the hoped-for better times ahead. The concern of tenants in these cases is simply to be able to say when the coming crunch happens that their underlying rental obligation itself has been somehow abrogated or reduced without affecting the rest of the lease. But I suggest tenants hoping for that outcome hope in vain. The term and the rental obligation under the lease go together. Both stand, or, following Panalpina, both fall. And in almost all cases, both will stand. Let us look at the underlying analysis. It will be a rare case where lockdown has made performance of a tenant's covenant under a lease illegal. But there may be some such cases, for example, where the lease includes a keep open covenant. Even leaving aside the John Lewis scalpel, it is for various reasons very unlikely that a landlord would have a claim for any remedy of any kind under such a covenant arising from closure of premises during the lockdown. But the John Lewis case seals the deal. It gives the court a means to deal with this situation which does not require the lease to be frustrated, and it does so while leaving untouched the tenant's liability to pay rent. As earlier mentioned, the only way a tenant can be absolved from having to pay rent under a lease by reason of performance of other non-rent covenants having become illegal is if the illegality itself is enough to frustrate the lease in its entirety. There is no way out of that dilemma for tenants whose only wish is some relief from their obligation to pay. But the prospects for any tenants who do want to argue frustration will in most cases be no brighter. On a relatively positive note, one thing they will not have to worry about is the Schlesinger decision. Unlike Mr. Schlesinger, tenants cannot assign away the problem of lockdown. However, the other indications for tenants wishing to argue frustration are almost all negative. In theory, leases of premises which were forced to shut by lockdown, or whose customers were all forced to stay at home, could still be discharged by frustration on a Krell and Henry type basis. Many such leases will contain covenants restricting use of the premises save for a particular permitted purpose or purposes. Closing premises will not breach a negative covenant of this sort, but the covenant may afford evidence of the tenant's non-promised expectations that lockdown has defeated or interrupted. Nevertheless, on the facts, such a case will be very hard to make out. Many businesses, though they had to shut to the public, adapted to use their premises to run home delivery services or online services and so on. A court is likely to be swayed by the argument that a tenant claiming frustration could still derive benefit from the lease in such a manner. That argument won't apply to businesses which rely on attendance at the premises by the public, hairdressers and so on. But even in such cases, tenants may have made use of the premises to house their stock. And most importantly, of course, the issue of the length of the business interruption caused by lockdown, in comparison to the original and/or remaining length of the lease, is likely to defeat a claim to frustration in very many cases. That concludes my survey of the law, but I have yet to mention the government's Code of Practice for Commercial Property Relationships during the COVID-19 pandemic, which you will all have heard of and some of you may have read. The Code does not purport to assert priority over the parties' legal rights and states, mostly correctly, that tenants remain liable for their rent in law. Where tenants cannot pay in full, the Code sets out certain possible rental concessions that the parties might wish to consider to tide things over. It also lays down certain principles to decide when, if at all, these different concessions might be appropriate. Among these principles is paragraph 16, stating, "Where businesses have received government COVID-related subsidies or reliefs, we recognise that this support has been provided to help businesses meet their commitments. This will include a spectrum of costs, from supplies of goods and services, as well as rent and other property costs such as insurance, utilities and service charges." The point made in this paragraph could well be relied on by landlords not only under the Code, but also in opposition to an argument of frustration relied on by a tenant in court. However, such a tenant is likely to argue that support is not earmarked to rent specifically, and is therefore still not enough given the other commitments which the support must also cover. Finally, paragraph 18 of the Code says this: "We recognise there will be cases where landlords and tenants have followed these principles, but have been unable to reach a specific agreement. They might both feel that a negotiated outcome could still be achieved, and therefore a third-party mediator could be employed by mutual agreement of tenants and landlords to help facilitate negotiations." It is well worth noting that in response to this paragraph, the RICS Dispute Resolution Service has set up a COVID-19 Commercial Rental Independent Evaluation Service. Full details of the service, including a superb user's guide, can be found on the RICS website. To pursue an earlier analogy, I suggest this service can be seen as laser surgery and is to be recommended to all commercial landlord and tenants seeking a means to best cope with the extraordinary times in which we are living. Thank you.